Judgment in the appeal, Bailey and another, and Angove PTY Limited.
Lord Sumption will hand down the judgment to the court.
This appeal arises out of the insolvency of a company called D&D Wines International Limited, which went into administration in April 2012 and into liquidation in July of that year. The onset of a corporate insolvency almost invariably causes hardship to those who have dealt with the company, especially in the period immediately before it went into liquidation. It frequently does so on a rather arbitrary basis. Those who are owed money by the company or have paid in advance for goods or services not yet received will lose out. They will have to prove their debt in the liquidation and will receive only a dividend. Others, who had paid their money or had their contracts performed just before the axe fell, will, as a general rule, be fine. These results may seem capricious at first sight, but they are necessary in order to achieve the main object of any scheme of insolvency, which is a proper rateable distribution of the company's assets between its creditors at a single common date. D&D acted as an agent and distributor in the United Kingdom for wine producers and importers. One of those producers was an Australian winemaker called Angove's Proprietary Limited, the appellant in this appeal. One of D&D's functions was to sell wines as Angove's agents to retail chains and to collect the price due to them, which it would then pass on to Angove's minus its agreed commission. At the time when D&D went bust, it had sold wines worth just under 900,000 Australian dollars to customers on behalf of Angove's, but it had not yet collected the price. The contract between Angove's and D&D provided that if either party became insolvent, the other could give a notice terminating it forthwith. Angove's had no desire to see their $900,000 collected by the liquidators of D&D and shared out between all its creditors, so they at once terminated the distribution agreement and notified D&D that they no longer had any authority to collect money on their behalf. Angove's proposed to collect it themselves. The liquidators argued that their authority to collect money due to Angove's for wine sold was irrevocable. This, they said, was because D&D needed to be able to collect the price of the goods sold in order to deduct sums due from Angove's to them, such as their commission. The liquidators said that for this reason they were entitled to collect the outstanding $900,000 and leave Angove's to prove for that sum net of commission in the liquidation. The Court of Appeal accepted this argument. The Supreme Court does not. Agency is a relationship of mutual trust. For that reason, the law has always recognized that a principal may terminate the authority of his agent even if he has agreed not to terminate it. If the principal has agreed to make the agent's authority irrevocable, the agent can sue him for damages for breaking that agreement, but the termination will be effective. The law will not require the principal to go on employing the agent against his will. To this rule, however, there is an important exception. If the authority has been given to the agent in order to secure some personal interest of the agent, such as a debt or an interest in property, then exceptionally the agent can insist on continuing to exercise his authority until the debt is recovered or the property is secured. This is the exception on which the liquidators of D&D rely here. In the Supreme Court's view, the exception does not apply for two reasons. The first is that there is no provision in the distribution agreement between Angove's and D&D which makes D&D's authority to collect outstanding bills irrevocable, and a number of indications that it is not. Secondly, although it would undoubtedly have been advantageous to D&D for it to have the right to collect the money and deduct what was due to it, there is nothing in the agreement that shows that they were intended to have such a security. On this ground, the Supreme Court unanimously allows the appeal. There is another issue, which technically arises only if we were wrong about that, but which we deal with anyway because it is an issue of some importance which has troubled commercial lawyers for a long time. Angoves argued that if the liquidators were entitled to go on collecting money on their behalf, even after the notice terminating their authority, the liquidators would hold the money in trust for them. It would not form part of the insolvent estate to be shared out among the creditors. They relied on 2 cases in which it had been held at first instance that if money is paid to a company which was either insolvent or on the verge of insolvency, so that the quid pro quo for the money would never be forthcoming, it was the duty of the company to repay it in full at once, and if they did not, they would hold it as constructive trustees. In the Supreme Court's view, this suggested rule has no basis in legal principle and is inconsistent with the statutory scheme governing corporate insolvencies. The 2 cases in question should no longer be followed.